Okay, this is arrestafield bug report number 18. So I assume that you probably, if you listen to number 17, hopefully you got my point. So I want to go on from there, all right? Randy might consider it superfluous, but that's my evidence. That's my reasoning, all right? And I think you consider what I said before superfluous because you're looking at things from the perspective of Texas code, not Virginia code, and not any other code. Okay, there's 48 other states besides Texas and Virginia. All right, now I don't know how it works in other states. Okay. So, I looked at the Texas code. It does say, you are to appear before a magistrate. But the whole purpose of appearing before a magistrate is to figure out, for the magistrate to figure out if they got jurisdiction or not, subject matter or personal. And you're on to that issue all the time about, do they have subject matter jurisdiction? I'm saying exactly at what point do they assume that subject matter jurisdiction? Okay? At what point do they assume it? Think about that. Exactly what time, what place, when does it occur? All right? Okay, let's not go to the judge, show up at the hearing and debate with the judge about this. Let's have some evidence of that shows you exactly when they assumed it. The judge is just going to say, I have subject matter jurisdiction, that's it. He's not going to debate it with you. In my opinion, you really have to get really specific about exactly when they assumed it and then point out the fact, have evidence of that, of when it occurred, when and where it occurred, and then complain about the lack of an examining trial. Okay, and what elements there need to be in place to have a valid examining trial. Right, and that's what was being discussed in those statutes. All right, you got to be able, in order to make an appearance, all right, you have to be able to see and hear and speak to the magistrate. All right? And the magistrate has to be able to see and speak to and hear you. All right? That is the main element. Not just the officer, by the way, but the accused as well. And in that statute, it does use the word examine the officer. Examine, okay? I went over that, and this is where I was going. I read it so fast because I was trying to get it all in before, because I knew you had another caller. And I realized, I'm still studying the whole the other issue with the mall, but I got a statute there that's going to be very interesting as well. I can get these guys, halfway fired. It only takes 2 complaints to get them fired. And I guess I can only make 1 complaint over this, but I can get at least 5 cops halfway to fired. So anyway, but that's Virginia Statute 19.2-59. Anyway, I mean, it says that, you know, without a warrant, if you do a search without a warrant, you know, that's malfeasance. They shall be guilty of malfeasance in office. I like it when they said shall be guilty. It's like, that's an order. Anyway, that's about the mall. But yeah, I suspect that those guys are going to lie, and they're going to say, "Well, we took him back to the police station, and then we thought that he was going to be a flight risk or something, so then we put the handcuffs on him. But that was afterwards." And nonsense. Yeah, they're going to come up with some nonsense, whatever it is. But anyway, listen, again, Virginia, this is the evidence. All right? Defendant name. The cops can't call you a defendant in a court case. And only the magistrate can do that. And that's only after assuming jurisdiction. Okay? You know, this is what I was trying to go after before, like maybe a year or two ago. You said, you know, I asked y'all about how does the court set up a case. And really, y'all didn't know, and the court pretty much does whatever it wants, and that's part of the problem. But that is when they assume jurisdiction. Is when as soon as the case is set up, and they have you named as the defendant. I don't get repetitious here, but you know, this is not a superfluous issue. All right, this is exactly where I was going. I want to read again. You know, and actually I went over this in the bug reports number 15 and 16, but you know, I just feel like reading it again, and if you want to listen, or you can stop the video whenever you want. But let's see, where is it? I got it highlighted. You know, and I like this particular statute partly because it tells you its purpose. Okay, and it lays it out for you. All right. A person arrested without warrant shall be brought forthwith before a magistrate or other issuing authority having jurisdiction. He shall proceed to examine the officer making the arrest under oath. If the magistrate or other issuing authority having jurisdiction is lawful probable cause upon which to believe that a criminal offense has been committed and the person arrested has committed such offense, he shall issue either a warrant under the provision or a summons under the provisions. Okay. Brought before a magistrate or other issuing authority having jurisdiction shall include a personal appearance before such authority or any two-way electronic video and audio communication meeting the requirements. Okay, I'm assuming, no, I'm not assuming, they are assuming. Okay, get this, you know, this is, you know, I see all the elements of an examining a trial when the cop goes back to the patrol car, gets all your personal information, goes back to the patrol car, somehow gets contact with the court and arranges the bail bond hearing, and somehow jurisdiction by the court is assumed, and the officer, you know, under the authority of the court, the officer gives you a summons. Okay? You know, that summons is part of the disposition order, which is definitely a court form. Okay? And on that form, it does name you as defendant. And online, that's how it shows up. Online, okay? Online, you look up your case, you will see, before you see the judge at all, you've already been named defendant. Okay? They must have already assumed jurisdiction before they can name you defendant. Subject matter jurisdiction first, then the personal jurisdiction. Okay? I want to narrow down the exact time and place this occurs. That's what I'm after. All right? And that's supposed to occur in the examining trial. All right? So, the only time that the examining trial could have occurred is out there on the street when the cop goes back and somehow communicates with the court. That is, and then issues the summons. Okay? Because the result of the examining trial is they assume jurisdiction or they don't. That's the whole purpose of it. I hope I've made my point. I mean, it takes a while. But, it's really straightforward to me, and I know you're used to thinking in terms of Texas code. But in the Virginia code, it lays it out. What's going on. It says the purpose, in order that the accused and the arresting officer may simultaneously see and speak to such magistrate or authority. Now, here's where I really was trying to go. And I'm going to say this really quick again. All right. Simultaneously see and speak to such magistrate or authority. Speak. The accused is being denied. They have a duty to let you speak to the magistrate, give you an opportunity to do that. They denied you that opportunity. Thereby, they limited your federally, constitutionally protected right to freedom of speech. Okay? Title 18, Section 241, 242. Deprivation of rights, constitutional rights. It's a federal offense there. Okay? That's what I was ultimately getting at. Okay? Irregardless of whether it's done by two-way communications or actual physical appearance, you've been denied, you've had your freedom of speech limited, and they are required by law to give you that opportunity. This is what I was really trying to drive at. Okay, and that's what, this is not superfluous, Randy. I mean, if your rights are important to you, this is not superfluous. All right, well, this is 13 minutes into it, okay? And Randy, I'm just going to go ahead and say this. Listen, I've noticed, I'm in my 40s, I've noticed that a lot of people, they get into mental ruts. They get into certain ways of thinking, and they have a lot of difficulty looking at things from a different perspective. I'm looking at things from the perspective of the Virginia Code. You're looking at things from the perspective of the Texas Code. And there's 48 other states. So I think you need to kind of get out of the Texas rut there and start looking at the Virginia and other states, okay? Because I don't know about other states, whether they're more like Texas or more like Virginia or just totally different. I kind of suspect that each one is quite different. So, but anyway, I'm not going to argue with you about commerce or anything else, all right? I've already got about 15 minutes into this, and that's it. All right, that's a arrestafield bug report, I think number 18. Thanks. Talk to you later.